welcome. You're about to enter into the world with Chief Rock and Winston Shrout. Now, this world that we're bringing you into is the world of commerce. For those have an idea what commerce is, hopefully you'll sit back, relax, listen, and learn about some of the ins and outs of commerce, some of the techniques, and some of the things that can be done while you're working within commerce. Winston Shrout Solutions in Commerce is www.wssic.com. You could go and order his workshop DVDs. He has many DVDs on there for sale. If you need any further information, I believe he also does some personal coaching. So I think there is a phone number there that you can call. And here he is. We're going to bring him on
everybody,
into this call right
today,
now.
Here on my my SoundCloud or my different MP3s, I have my interview here today with Winston Shrout. He's a very well known and very highly recommended man who talks about commerce and admiralty law and contract law. And I'm here have him on the phone today, luckily for me. And we're going to go over some ideas and some information to clarify a few things on the UCC 1 and other topics. So sit back, enjoy, and we're going to get into it with Winston right away. Winston, how you doing?
I'm doing okay.
So let's just get into the UCC 1. I mean, maybe we could touch on the UCC 1 and maybe give, some if you can cover a little bit on that of what it is and what it isn't, and just a quick overview and maybe talk about, filing the UCC 1 financial statement.
Okay, well, let me give you a brief history or a lead up to that so it's understandable. What we have, because we have evolved into admiralty jurisdiction basically all across the planet, the main consideration in an admiralty court is technically who has the interest, who has the secured interest, or in other words, who has a claim. And so paramount with any kind of controversy or any kind of consideration that goes on in these admiralty courts, the first thing to look at is the claim, who has the superior claim. And so the purpose of the financing statements is to demonstrate a timeline, perhaps. We used to term the phrase first in time, first in line, as far as claims go. Now, if you look at the Uniform Commercial Code itself, in particular, Article 9, where it talks about a perfected security interest, it delineates what is necessary to have a perfected security interest. And so we're not just talking about a security interest, we're talking about the perfection of the same. Now, it'll show you in Article 9 of the UCC that in order to have a perfected security interest, there are two things which are necessary. One is possession of the title, and number two is possession of the thing that the title describes. So, for instance, if you're going to perfect a security interest, let's say in a horse, if I can use that as an example, the horse, yeah, the horse itself would have to be registered in some manner so that the party has the title to the horse. And then he would also have to have physical possession of the horse to have a perfected security interest. So that would be the paramount claim upon that horse. And if there was any contest in a court situation, if one demonstrated that they had that perfected security interest, which was the title to the horse and possession of the horse itself, then that, of course, would be the superior claim. Now, in a lot of instances, especially with a lot of things we do in commerce, for instance, let's go to the concept of a car, an automobile. Uh, it, in most instances, it's impossible to have a perfected security interest in a vehicle because most generally the manufacturer's statement of origin has been gifted to the government, to the Department of Motor Vehicles or whatever, so they actually have possession of the title. What you generally have is possession of the automobile itself. And so how would you perfect a security interest in such a thing? And it would, I think you could probably do it administratively, but you see the split there. You see the split between a security interest and a perfected security interest. Now, when we start to make claims either for a security interest or perfected security interest and so forth and so on, then the method that we use to create a timeline is the UCC 1 financing statement and the filing or the recording of that instrument. Let me delineate real quickly here that there are basically two types of UCC 1 financing statement. The most popular one in use is what's called the National Form. Now, the National Form UCC 1 was actually created, I think, in 1988. Prior to that time, all financing statements were basically on what here in the lower 48 we would call state forms. Now, the difference between the two could basically be looked at in this manner, is that the national form creates a notice of interest on the collateral, that's listed on the form, whereas a state form is in fact a lien against that particular collateral. Now, there's a world of difference between the two, and the one should certainly look at the words and the difference between the two words of filing versus recording. For instance, the national form itself is generally filed with some Secretary of State in some state, perhaps where you're at. The filing would be done in Washington State, whereas the state form would be recorded in a county recorder's office, and it would be considered by the county recorder then in the form of a lien. So there's kind of a pretty wide difference between those two things. But again, the reason why we use these particular documents is to demonstrate an interest or a claim in some collateral.
Now, just to maybe clarify, the national form is the forms that everyone seems to be the more popular one because people are able to file them online.
Correct. Let me just say first off, I would never file online. I would always create the document itself. The reason being that if you use the internet, the electronic filing, it will automatically convert everything to all capital letters.
Yeah.
If I were going to use a national form, and sometimes I do, but if I were going to use a national form, I would fill the paperwork out by hand, and to make sure that the secured party is in fact a real man. In other words, I would write my name or the name of the secured party in upper and lowercase letters. And so that's how I would file that.
Yeah. So, would someone print it off their computer and then mail it in, or would they
Yes.
Okay.
Either mail it in, or if you can hand carry it in, that's better yet. The reason why I say that in either case, whether you hand deliver it or whether you mail it in, you're wanting certified copies of that filing so you can have that in your possession. So let's say, for instance, if you mail or you file or you hand deliver, you would automatically request. It only costs a few dollars, maybe $5 or $10 or whatever, to get a certified copy. But in any event, that certified. The reason why we would get a certified copy is so that it could be acceptable into evidence in a court.
And now, is there a difference between the certified copy that we get from the county recorder, or do we have to get a certified copy from the head of state or the?
Well, you could do either one. If you were filing in the state with the Secretary of State on a national form, then you would want to get a certified copy of that. Or if you were actually recording in a county recorder's office, you would want to get a certified copy of that. Just in case there arises some conflict, and it evolved into a court case itself. If you look at your evidence rules, I'm pretty sure they're pretty much the same in Canada, in the provinces, as they are here in the States. But if we wanted to introduce a UCC1 filing of either style into evidence, we would need to take with us a certified copy of such document.
And maybe to go back a little bit, before you even think about going in to walk in to fill out the national or to record, is it required to have the security, like the agreement, on hand in case they ask you? Because I know in a lot of my documents, I get the signing authority. I get them to agree to give me signing authority to sign on their behalf. So would that be needed, or do I just tell her that I have signing authority? Like what do you do?
There's two ways. A lot of people are, in fact, by tacit procreation, getting the agreement of the other party to be put onto a UCC financing statement as a debtor. But also, when you have exhausted administrative procedure against another party, that is sufficient to put their name on a UCC filing as a debtor. For instance, for those who are utilizing acceptance for value, that is administrative process, that's administrative procedure, and if you accept back, for instance, a presentment or something like that, and you want to put that onto a UCC financing statement, that acceptance is, in fact, the exhaustion of administrative due process, and therefore you're in a position that you could actually put the presenter of that document to you on a UCC financing statement as a debtor.
And as long as you had the administrative documents to show that you made a presentment and that they dishonored you and kept trying to collect that, even though you tendered that document back to them, you're saying that because they went in a default and dishonor, that you could go and file UCC one against them?
Not because of default and dishonor, but because you had exhausted administrative due process.
Okay. Meaning that you did all you can do is done. You go and file UCC.
Correct.
So I think a lot of people are confused. I think they think they get a few things done and they just run out and do it, and they didn't exhaust everything. And I think that's where a lot of people are getting in trouble, because I have a gentleman who wants to do a lien, and he wants to file the UCC one, but he hasn't exhausted his administrative judgment. He thinks that merely having the allegations and sending him the affidavit of obligation and them not rebutting any of the facts in there, that's his exhaustion. And I'm
No, that's not. That technically that's not an exhaustion of administrative due process. He should follow through with the notice of fault, opportunity to cure, and then the default in order to have exhausted.
Oh, okay. So yeah. That's what he wanted to do. He wanted to do the affidavit of obligation and then default them on that, and then go ahead and.
Well, he can go out automatically go to default if he so chooses. The notice of fault, opportunity to cure is basically a courtesy. But when we're in commerce, and we always want to be as helpful and merciful as possible. And so, when you send that original affidavit of obligation and they don't respond, there may be a valid reason. For instance, they were sick, they were in the hospital, they were out of town, they were out of country or whatever. And so we do all in our power to be as fair in the things that we do as possible. So again, the notice of fault is a courtesy, but it's one that we really should do.
Yeah. I mean, that for me, that's what I do. I'll make sure I get their agreement before I even think about doing an affidavit of obligation. I make sure I get there in harmony with my brother before I file anything like that.
Yeah, well, there's occasions when, for instance, if there's, you see, let me explain where a lien right comes from. All commercial interaction is a result of a contract or an agreement. And so we've had a meeting of the minds, and Party A has agreed to do certain things, and Party B has agreed to do certain things. And as a result of that, we expect a good outcome. Now, if either of those parties go into a breach of contract or into a breach of agreement, then that gives the other party a lien right. And so if the breach can be demonstrated, then the party could go ahead, with a lien if they felt like that would be the appropriate remedy and so forth. Now, the other situation is where there's been a tort that's been created. Now, a tort is a short term for a tortuous action. And a tort is an injury outside of a contract. So, for instance, somebody comes over to your house and punches you in the nose. Now, that punch in the nose is not a result of a contract. That punch in the nose is a result of a tort, and so you certainly would not have to have the agreement of the other party to put a lien on, for having been punched in the nose.
Okay, so like a lien right can be made just from damage.
Correct.
Wow. I mean, people are getting damaged all the time. I mean,
Sure.
I can think of one group of people who have been damaged quite a lot, and I'm sure they have the biggest lien right in the history right now.
Yeah, I think Kevin up there, Kevin Arnett up there, he's pushed the thing to the limit. And if the last information I got from his efforts were they were fixing to do a commercial lien.
Oh yeah, I'm already in emotion.
Good.
I can't think of a bigger number than I've already thought of.
Well, if you look at the history of the dealings of the British Empire with the native people in what we call Canada today, the British Empire is holding literally warehouses full of gold, and they're holding it in trust, as they say, for the native people of Canada, but they're not giving the people the benefit of that. They're withholding it from them, and so yeah, well, the numbers do get pretty big.
My view on that, how you said that they're holding it for us in trust, and I know there's a trust out there, and there's an account that has like an unlimited value, because a lot of our some chiefs and some other corrupt people have been attempting to access it. And my thought on it is, when these people put that in trust, like years when they first got, when they first got here, we made agreements and contracts. We didn't make them. We didn't make these contracts as Canadians or Americans. We made them as the Haudenosaunee or whatever language we spoke at that time. And I feel that's the difference, because we incorporated ourselves and stepped away from that agreement that we made. So they're still waiting for the original people to come back and make claim, right? Would that sound correct? Or is that
not exactly? The whole well, we're getting into politics now. I'm not really sure that's where we want to go, but perhaps at some time we could discuss some of the ramifications of what's been done. It's different for different parts of what we call Canada. The eastern situation is considerably different than the western situation, where the western peoples are actually listed as allies of Her Majesty, whereas the eastern peoples were involved in war and conquest. So I mean, that would take a long discussion, perhaps, but just know that if in fact the people who are heirs of the original ones who made that contract or that treaty, the heirs do in fact have rights. And if those rights are denied, that's breach of treaty or breach of contract. And yes, indeedy, a lien would be a viable option in that situation. But let's go to other things.
Yeah. So now that we got the national, so the county recorder is where you go, and you record your lien, and there's a lien department that they're going to send you off to and have you fill out the paperwork for that?
Well, let me answer that. Some years ago up in Washington State, there was a group who started a private recorder's office, and so they were recording documents and so forth. With that, I don't know what happened to them. I'm sure the government probably jumped on them pretty hard for it. But my recommendation to you, where you have a nation, and especially if you can get recognized by The Hague, that you would in fact establish a recorder's office, for the native people, so that their documents and so forth could be recorded without the county recorders, and all the trouble they cause. That's something for you to think about.
Yeah, I already thought about it. I was just, in my mind, I was figuring how to I guess I'd have to start up my own office or something, and
yes,
and have people pay us to file things, and just kind of keep it our own storage and filing system.
Yes. I would suggest a hard copy recording, and also electronic. And you'll have to guard it safe and fireproof vault or whatever necessary for you to do. But one of the problems we run into is that the governments have instructed many of the county recorders not to record documents, from what they call the sovereign movement. So in many instances, we run into problems, because of that, and simply are not able to get county recorders to record documents. Now, one of the ways, and this might be helpful to you, especially if you're going to record down in Washington State or Idaho or Montana or wherever, if you have a resistance from the county recorders, what we generally do is that we create a power of attorney and have that as the top document on several documents that we want recorded, such as a commercial lien or other documents and so forth. And so with that power of attorney sitting on top of a number of other documents, we seem to have been able to get those documents recorded.
Now, how's that? What do you mean? I know what power of attorney is, but what is the power of attorney in give you power over? I know you could.
Well, let me just give it to you this way. And we have found in many instances that rather than doing things firsthand and in person, that we ought to be doing everything at arm's length, such as, let's say somebody wants, to do certain things, create certain documents, so forth and so on, it would be a very good thing if they gave power of attorney to another party in regards to those documents, so that the original creator of the document keeps it at arm's length. Now, a very good position to do that from would, in fact, be from the position of a notary. A notary is, in fact, a consul or a consulate. And so, especially if you're crossing jurisdictional borders with some of the things you're doing, it would be the very best position, number one, to be at arm's length, but number two, for a consulate to deal with the documents and what happened with them. So in that instance, power of attorney to the consulate, so forth and so on, would be a very favorable position.
Yeah. I mean, without you even bringing that up, a friend of mine was wanting to do that because they can't cross the border, so they wanted me to go and do that. And I was thinking, well, I'm going to have to do a power of attorney over this so I can file, but I was wondering, are you able to sign on behalf of the debtor party?
Well, of course. When you give power of attorney, you would be given, you can either give limited power of attorney, or you can give complete plenary power of attorney to an individual. I would suggest limited power of attorney. Now, the other position you might work this from is from the position of a trustee. For instance, the original party who had created the document would nominate or appoint, someone, anybody for that matter, to be their trustee in regards to that particular matter. So again, we're keeping it at arm's length, and the position of trustee is a very, very favorable position.
Yeah. See, I love the ideas. I never thought of that one. That's a good one.
Okay.
So okay, great. Now so I'm getting clear on the counter recorder going in, and if you can get in and get the UCC 1 financing statement filed. But again, you don't need to bring your agreements with you to provide any proof. You just you can go in there and just put it down as it is, or
technically anybody could walk into a recorder's office and record any document. But I think probably the most favorable position would be to keep it at arm's length and have a third party, such as a power of attorney or a trustee, actually going through the filing.
Yeah, and then that way they wouldn't have any conflict or reason to conflict with you. They would have to file it.
Well, hopefully they would. We have run into some problems. Some of the bigger counties where there's been a lot of activity by the what's called sovereign citizens, they might be resistive. For instance, down in Nevada, one of my friends down there, he was doing a lot of recording in the county recorder's office, and they finally, just basically threw him out. So he simply went over to the next county and didn't have any problems over there. So where you're at, if you're coming across the border into, I don't know, it's Snohomish County or whatever it is up there on the border, that might be a lot more favorable than trying to go down into King County.
Oh, okay. Yeah, okay. I see what you're saying, yeah.
Or into Sandpoint, Idaho, or to, some of these places, that don't get a lot of foot traffic.
Yeah, so they'll get excited when someone comes in because they don't really get much people in, right?
Yeah, it's kind of like that. So sometimes we just have to, be as harmless as dove, but be as wise as a serpent with some of these things.
Now, I was also listening to about the evidentiary jacket in some of the courts to file documents.
You're talking about the miscellaneous file in the United States District Court?
I guess if that's what you're calling it now. But from when I was watching it, you were saying something about an evidentiary jacket, or a jack where you could stuff evidence into and then get certified copy.
That would be called the miscellaneous file in the United States District Court. There are some drawbacks to that. Let me describe how to go about doing that. What you would do, you would take whatever documents that you have to the clerk of the United States District Court, and you would tell them that you want to open up a miscellaneous file. Now, and so they might ask you the question, well, what do you want to open it up for? And you might say, well, I anticipate doing a civil suit, and I need a place to lodge my documents in anticipation of doing that. So they usually don't have a problem with that.
Yeah.
Now, theoretically, any kind of documents like that come in, the clerk will take them directly to a magistrate for judicial review. You may or may not want that to happen. And so you have to tell the clerk, what it is you want. And so you might say, well, just tell the clerk, this is not for judicial review. This is simply for storage in anticipation of some other things. Otherwise, they'll take it straight to a magistrate for judicial review, and then sometimes you get into a little bit of a problem with that. So, but here's the key. Here's the key that when you file those documents into the miscellaneous file, immediately ask for a certified copy of that filing. The certified copy is going to have a file stamp on it, which is going to establish a timeline. When did the thing start? So that's why I keep emphasizing getting, that certified copy. So in the future, if you need to use that certified as evidence in a court case, you have it ready to go. Now, there's one drawback to using the miscellaneous file, and that is it'll only stay active for, I think, either 5 or 6 months. So it's not the same as a county recorder's office. And
do you file your originals in there, or you just
Yes.
Okay.
Yeah.
And then after 5 months, you have to go pick them up.
Then they might just return them to you. I don't know exactly what they would do with it, but yeah, whatever you put into that miscellaneous file has to have an original signature on it. Now, for instance, if you wanted to retain the original to yourself, first off, it's important to make more than one original.
Yeah, that's what I was thinking. 2 originals.
One fellow I knew, he made 7 originals of everything he did. And some of them he kept in lockup and hiding places and different things, just on the chance that something might happen down the line to where he might have to go back and get another original. What you might do is when you go to the miscellaneous file, you might take, for instance, 3 originals with you. Leave 1 original with the clerk and have them file stamp your other originals, plus get a certified copy.
See, that's what I mean. I haven't done that in Canada, and I'm going down to the courthouse to kind of snoop around and ask about that, if we could open up a miscellaneous file like that.
Yeah, I don't know if it applies in Canada or not, but certainly it does in the United States and the U.S. District Courts.
Yeah, so you never heard of anybody, any of your seminars, anybody have already doing this then?
Yeah, people are doing it all the time.
Oh no, in Canada, I mean, in reference to.
In Canada, no, I don't know the answer to that.
Yeah, okay. I mean, I'll let you know when I do, or if I can, or I'll give you feedback on that. Now, okay, so on the national form, I noticed that there is no signature, and that there was a little bit of discrepancy of whether you wanted to make your document a what's that called, entity. What's that?
Transmitting utility?
Yeah, there we go. Transmitting utility. Whether you wanted to do that or not.
Yes, I would, on the basis that if you don't, the UCC filing will go dead after 5 years. It probably will anyway if you file it with the Secretary of State. But let's say, for instance, you wanted to use a national form and you wanted to record it in the county. You can record a national form in the county. Now, even though there's no provision on the national form itself for a signature, that doesn't mean you can't put one on it.
Yeah.
And also down in the collateral box, you can simply make a box down there and check it off where it says debtor is a transmitting utility. You'll have to add it because they don't have it in there. But it's your form. Make it up however you want it.
Yeah, I mean, handwriting supersedes printed. Am I right?
Absolutely.
So yeah, okay. Because I make contracts with companies like cellular phone companies, and I cross out a lot of stuff and add things, and they don't like it, but they sign up because they want my money to do the interaction, and then they get in trouble because the company goes, well, would you let them alter the contract? He's only paying $2 a month now instead of our $60 or $70 a month. And then the guy goes, well, what would you cross all that out for? I was like, well, I'm amending it. This is how I want it. I want to pay $2 a month. He said, well, in his mind, he was thinking, whatever you're doing isn't going to affect. We're still going to charge you to $70. But no, I sent a memorandum and conditions. If they want to pull out of this contract, it's $100,000 and
sure,
all that sort of thing. And they they didn't want to. They got real jumpy about that. So
well, what they don't realize is that contract is prepaid anyway.
Yeah.
And so what they're hoping to do is get past the prepay and start to collect equity money from you. That's what they're trying to do. It's theft by deception. I mean, they've been doing it for years and years, but that's all it is theft by deception.
Yeah. Well, that was just an example of me altering and superseding the printed, right?
Sure.
Yeah. So yeah, this is really good stuff. I mean, I myself haven't filed a UCC one. I've seen the national forms online electronically, and a friend was saying that if you do an amendment to your UCC online filing, it makes it live or something, or
there's a lot to all that, but again, I would recommend not filing anything online.
Yeah, got to go down there, and that
go or mail it. The mailing is just slower.
I guess you'd have to send your payment in along with the. Okay.
If you request a certified copy, you have to include that in the mail and so forth. You can call ahead and find out what the fee is, and probably provide a self-addressed stamped envelope, so they can send it back to you. But it's a little bit slower. So
okay, we get this done. We filed it, or we have the affidavit of obligation. We have the agreements. Everything is solid, and now we get a certified copy from the Secretary of State of the UCC one filing, and then I think a lot of the people are like, then what? And I try to tell them that you could take that and go to a private bailiff or a private sheriff, and have them go and enforce it, or get a judicial review and get a writ of assistance from the court to go ahead and seize the accounts and property. Is that my off?
That's that's how it works if you were trying to seize property. I don't know exactly what people want to accomplish. Most people use the UCC filings to basically secure their claim on the straw man and upon the estate. And so it's not a matter of going and collecting stuff. Now, there may be situations. For instance, I was approached some years ago by a lady who ran basically it was a paycheck cashing business. In other words, you come in, you're short on money, so you got $100 loan or whatever to payday. And she was having a real hard time because she was losing a lot of money because people simply would not come and honor their agreement. And so she said, what could be done? I said, well, when they come in, have them put up collateral on a UCC1 financing statement, and if they don't come in with some money that they borrowed, just have the sheriff go pick up the collateral, and they will.
And I'm wondering, why couldn't she? Because what she's getting is promissory notes from people. Can't she? Because she's a company? Is there a way to go to the federal window and get paid?
No, that would be very difficult. that's not too hard for big companies and perhaps comptrollers of currencies and things to do. But, for a small business like that, it would probably be impractical. But, in her case, somebody comes in and borrows, say $100, he puts up his motorcycle. Well, motorcycle is considerably more valuable than $100, so he'd be more prone to come back in with that $100 than have the sheriff come out and seize his motorcycle, which he'll sell.
Yeah, yeah.
So you can use it in whatever way is applicable to whatever it is you're doing. But for, like I say, most people, they're simply trying to get into a position so that if ever there's any kind of a controversy, a court case, or some of those things, they can demonstrate that they have the superior claim on the debtor.
Well, I have people who are in situations where they were beat up by the police.
Well, that's a tort.
And so they sent out documents with affidavits and getting them to agree that they owe this gentleman for his mental and irreversible mental anguish, say, I don't know, $5 million or $200 million or whatever the amount was the guy was going after. But he didn't know whether the bailiffs would go after a corporation like a police station.
They will go after him if you go through the legal process. Now, you said $5 million or $200 million. $200 million is way out of line. First off, the bonds of the policemen, will not cover $200 million, but they will cover $5 million. So what you would have to do is you would have to press that claim through the court to get a judgment in his favor. And once that judgment was let, then in fact he could go and enlist the help of policemen. In our case, we might just use the sheriff or the United States Marshals. Yeah, I think you can still use the U.S. Marshals where you're at. Shouldn't be a problem. They're an international group.
Really?
Well, yeah, they're a part of Interpol.
Woo! That's awesome. I had no idea, man. That's good. That's good. I mean, but
the RCMP, the U.S. Marshals, all those are simply subsets of Interpol.
Huh. I didn't even realize they had any connection with.
Oh yeah. So if you get into a situation where you can in fact get a judgment, for $5 million or whatever, then if you think that local police are a problem or the RCMP is a problem, then contact the U.S. Marshals. They have a form you can fill out if you can get a valid court judgment. There's a form. It's called the USM, which stands for U.S. Marshal, Form 285. You go and fill it out. You present it to them. You make the arrangements, and they'll go do the collection for you.
Wow. Well, so you're saying that the judgment can't be made in the private and then judicial reviewed in the public?
Yeah, it can be judicially reviewed, but see, in order for the U.S. Marshals to act, they will only act upon a court judgment with a writ of assistance from the clerk of the court. Now, in the case here in the United States of a sheriff will go and do a collection if you will bond them. For instance, let's say it has to be it can't be $5 million. That's way too much for a sheriff to deal with because So let's say it was $10,000. And so you got a judgment for $10,000. You got a writ of assistance. You go down to the sheriff. You go buy a sheriff's bond, which for $10,000 probably only be $100 to you, to buy the bond. But once the sheriff is bonded, he'll go collect. If he has to do a till tap or if he has to seize property or whatever he has to do, he'll do it.
Wow. Okay. Yeah, I mean, in Canada, I'm not sure. I think the U.S. Marshals would be the best route for anybody. I think
it might be. Like I say, RCMP. I don't know how easy it is to work with those folks, but you can always just drop down to Seattle or whatever and deal with the U.S. Marshals down there. There might even be U.S. Marshals in Bellingham. I don't know.
Yeah, it's good. It's a good route. Because a lot of people, they're getting a lot of the police in Canada no one knows how to enforce. The guy says, well, if you want to take my private property, because, they steal private property all the time. and they'll verbally contract with somebody, and the guy's like, yeah, sure, whatever, so he's engaging verbally with these people and not expecting for them to come collecting for what they agreed on.
You're talking about a repo man?
Well, yeah, the cop will pull someone over, take the guy's vehicle, kind of thing, and the guy's like, it's my private property. You can have the title because that's what you're entitled to, but they take the whole car and they get a tow truck to come and do it, and
That's theft.
so they're contracting with the police guy and the tow truck guy, and plus they have a notice on the car that says any towing or anything in this is going to be agreed to this, and don't tow it unless you agree, and all that other kind of stuff.
Yeah, I know. Well, some of those things you just have to work with. If they do it to you and you're successful in your prosecution of that theft, they'll never do it again. At least not to you.
Yeah. Well, that's what I was saying. Like, I don't want to do it, but there's some guys out here who are getting in trouble or getting beat up, and
Well, they need to stop getting into controversy with the policemen on the street. First off, they're trained that if anything is out of the ordinary to go physical. And so, rather than get into a street fight with the policeman, just go into an agreement and then settle the thing in court. There's no reason to get violent with this stuff.
Oh yeah. I always that's what you just said is exactly the mentality that I'm trying to put in their head. But the one guy would just walk in to be a witness for his friend, and they slammed him on the concrete for no reason.
A witness where? You mean on the street?
Well, his friend was pulled over, and he just came to watch and witness what they were going to do with him, or whether they were going to have any misconduct.
Distance.
Well, he tried to get a little closer, and that's when they grabbed him, slammed him. So.
Well, I understand all those things, and it's a sad situation that's the way that the police act. But if that's the way they do act, there's no reason to get into a scuffle with them.
Right. Well, I guess that what they want to do is make an example so that they'll stop acting that way.
Okay, well that's fine. I mean, if he has some cause for doing it, that's fine. But generally speaking, there's no reason to go physical with these people. First off, they have guns.
Yeah, that's what I always tell them.
A lot of them are ex-military and all that kind of stuff. They haven't killed anybody for a long time, so they're just likely to kill you as anything else.
Yeah.
And especially in Canada, where where the political situation is, they want to get the native people off the land. If they have a reason to shoot you, they will. So don't give them that chance.
Yeah, no, this isn't native people doing it. These are just
anybody. Okay. Yeah, well, same thing applies. There's no reason to get into scuffle over that stuff. Go settle it in court.
Yeah, well, that's what I keep telling them. I said just let them do what they do and deal with it with the paperwork and later. Just walk away. Mm-hmm. But so maybe let's get into bonds, I guess, and like you just talked about identification bond and bonding the sheriff and maybe promissory note bonds, because when people are making these bonds and they're making presentment to them, they're not getting remedy, or they're being stolen. Is what's happening, I think. Because they're not tracking this bond or putting it on the UCC one or recording it publicly. Is that the main issue with that?
It could be. I don't know. Let's go over the concept of bonds and promissory notes here for a moment so that people understand what they are. A bond is simply a guarantee or an insurance policy for another instrument. In our particular case, it would probably be a promissory note. And so we have to have that insurance because when we're dealing with the notes, we're dealing with deferral or discharge items, so they are limited liability. And so if that's the case, if you're issuing notes and so forth, then there has to be a bond attached. Now, okay, I don't know what it is you're showing me there, but
it's an old bank draft from 1930 with the stamp on it, and I think this is what a promissory note is, the basics of a promissory note.
No, if it's that old, it's actually a draft. Most recently, bank checks have turned into notes, but at the date of that instrument, that's a draft.
Ah.
And now, when was that? When was that issued?
1939.
Yeah, that's a draft.
Same as all the other ones I got.
Okay.
They got stamps on them.
Yeah, that was typical in those days, and we use stamps also for the particular reason of guaranteeing the security of the thing. That's another subject. But let's go back to the concept of bonds that you had originally been asking about.
Yeah, I was just showing you what I had.
Sure. Okay. Now, in our case, that we are using House Joint Resolution 192, the 5 June 1933, and also Public Law 7310 as the bond for the notes that we're writing. Now, if you don't use those particular items, for a note, then you're going to have to produce a separate bond. And, that's an alternative way to go and altogether unnecessary if, in fact, you use these other items, because HGR 192 is technically it's a super sedeus or an umbrella bond under public policy. So if you look at some of the notes, that I've shown over the years, whereas we're writing the note, down in the memo section of the note, we'll put, something, that this is like, based upon HGR 192, Public Law 73-10, and so forth and so on, as in fact the bond for the note. Now that in and of itself is sufficient bonding of that note. If you don't use public policy as the bond for the note, then you would supply a different bond. One of the bonds that we've shown in the past is in an indemnity bond that we actually send to the U.S. Department of Treasury so that it can be screenable. In other words, let's say you send an indemnity bond to the U.S. Department of Treasury. They process it, put it on their screen so that if you wrote a note and somebody questioned the note, you say, well, this is based upon indemnity bond number such and such, they could actually contact the U.S. Department of Treasury to see if that bond does in fact exist. And so that's another method, that we've used and so forth to guarantee notes and so forth that we've written. So when you get down to it, notes are a useful instrument in some circumstances. Certainly, my preference would be accepted for value, which creates a draft. A draft, that doesn't need a bond because the asset actually exists that you're drafting against, so you don't need to have an insurance policy for an acceptance for value. But anyway, if people are using notes, then the bonds are appropriate.
Okay, so if someone gets a presentment, say like a hydro bill, and at the bottom is that check, that remittance voucher, and they accept the top portion that they're saying that they owe for value, and then creating a sort of a check out of the check or writing.
It's not a check; it's a money order.
Oh well, what's that? Yeah, money. That's okay. Money order. If you make a money order and put the amount and you endorse it, flip it over and endorse it, that's now a draft, and you can, because they already have all the routing numbers and stuff kind of on the bottom of that.
Yes. Let me explain about negotiable instruments. There's only two kinds of negotiable instruments. There's a note or there's a draft. A note is a discharge item, which does not extinguish the debt. It simply puts it off into the future. It defers it. However, a draft is an instrument which will reduce the account to zero. Now, when we do these acceptances, we accept the statement of account, and then we turn the coupon, or the remittance, as you're calling it, into a money order, which is, in fact, the bill of exchange. The purpose of the bill of exchange is for set-off. In other words, they can take that accounting information and so forth, and they can actually reduce the account to zero. So that's the difference.
Yeah, and so this would be a draft then, is what you're saying. But this would be
Yes.
on this
Yes,
would be on the bottom.
That's a
Yeah.
draft.
Yeah.
Uh-huh.
And so something like this, if it was created, you could take something down into zero instead of setting it off.
Correct.
Huh.
It's see, sometime or the other, when people get a little bit into their learning process, they're going to have to learn the difference between open accounts and closed accounts. An open account is an account where the interest is still running. A closed account is where the interest has been the account is closed, and so there's no interest involved in it. It's very much the same as closing or collapsing a trust. In other words, if you remove all the assets out of a trust, the trust automatically collapses. And so, if you have an account which is a trust, I mean, it's in the form of a trust, and if you reduce the account to zero, then the trust or the account collapses and is called a closed account. That's just a little bit advanced thinking. Maybe some of your students are not quite to the point where they can conceptualize that yet, but that's the purpose.
A little bit. One of them actually is an electrician, and he understood the open circuit to the closed circuit.
Sure.
And the closed circuit, meaning that the energy is going to flow and it's unlimited.
Correct.
And so he was under how do we make a check from that closed, because he has a couple closed accounts, and he never knew that he said they're always there, but because he was brought to court on it, and they brought actual records from the closed account, so it's still open. So he was asking,
well,
and I was like,
no, it's once you open a bank account, that number on that account is only used one time ever. So if you talk about going in and closing the account still, the number of the account still exists, but the account itself is closed.
Yeah. So, but that closed account can be used for set off now as well. No. Yeah, I heard people using it.
That's advanced technology, and I'm not even about to go into that.
Yeah, I always tell anybody who asks me about closed checks, don't do it, because you don't know what you're doing, and I don't know, so just don't.
That's the best position.
Yeah, I said just don't, because you're gonna get spanked, or someone's gonna come looking for you, because you hear stories about it, but just because you hear stories don't mean that the story's true.
The stories may in fact be true, but there are certain. I mean, it probably is not being fully explained to you. So I would be hesitant. I mean, that's way down the line in people's studies.
Yeah. So back to the notary presentment. Can you do the notary present? Say I had a bond or a promissory note, and I had a notary presentment who I put the bond into escrow with, because when you hand over your bond to him and they're holding on to the original, that's escrow, correct?
Yeah, basically what we've done in the past, there's actually two entities that can make presentment of an instrument. Number one is a bank. Number two is a notary. We stopped using banks for presentment on the basis they usually try to steal the instrument. So if you take an original instrument to a bank, they'll try to steal it flat out. So we stopped using banks altogether. So yeah, if you want to use a notary for presentment, you would take the original document for the notary to hold in escrow, and then the notary would contact the party, the other party, and basically tell them, I have certain instrument here in my possession. Here's my office hours, here's my address, here's my phone number, and you have 10, 20, 30 days or whatever to come in and to either honor or dishonor the instrument. Now, typically they don't come in, they don't give honor to the instrument. So at that point, the notary would return the original back to the to the original party, along with a certification of dishonor. Now, that's not a protest. People get those words mixed up. A notary protest is altogether different than what we're talking about here.
Yeah, I was just about to ask about that.
Yeah, it's not a protest. And so the notary would simply return the original along with a certification of dishonor. And if you don't have examples of that, I can send you a copy of a notary dishonor.
I think I do have something. I have to look, but I'm sure there's a notary dishonor out there somewhere. No.
Well, yeah, I've given them in various seminars and whatnot. If you don't have a copy of that, if you just send an email to the office, I'll send you an example.
Okay, or I could. Yeah, okay, I could do that. Yeah, I don't have one of that.
But it is not a notary protest. People need to stop using that word. They're using it incorrectly.
Yeah, so a notice of dishonor, just giving notice that there's been a dishonor of your.
It's a certification of dishonor, not a notice. It's a certification of dishonor.
Oh, hold on. I think I have something. The undersigned notary did present the attached bill of exchange as consideration on a private offer. Notice attached given.
Yeah, something about, like that. Yeah.
Yeah, allowing for 70. Yeah, so just letting them know that, hey, we had a private offer. They defaulted or didn't come in.
No, not default. Dishonored.
Oh, dishonored.
You use the right words here now, because you get mixed up if you don't.
Yeah.
They dishonored it. Because the word dishonor has a great deal to do with the UCC in regards to a tender of payment and dishonor. So we're not talking about default here. We're talking about dishonor, which is a legal term that appears in the UCC.
And that discharges you of all obligations of any liability.
Correct. That's UCC law.
And UCC covers universal because it's like Canada is a registered company to the United States, so it would cover up here. Yeah.
Uh-huh.
People try to argue with me that it doesn't. And it's like, well, I'm not arguing. I'll agree with you, but we'll agree to disagree.
Well, the argument stops when you go do the process and it works.
Well, I was in the Supreme Court, and I saw a lawyer jumping out of his chair trying to get the Supreme Court judge to get the UCC filing off his property or whatever, and the judge is shaking his head. Man, I can't help you. Nothing I can do.
Of course.
And this was against this was the native people who dropped a UCC one on them. It's actually Matt. Man, I'm not sure I can say his name, but
don't say his name.
Yeah, but you know who I'm talking about. Just
Martin. His white name Martin. His native name's Max. I know you're talking about.
Yeah. I don't know his white name. Actually, I think I know. Yeah. Marlin.
Marlin, that's it.
Yeah.
Actually, Martin's the chief's name, so I get them mixed up.
Yeah. It was him. Those guys got those guys jumping out of their seat.
Yeah, Max does a lot of fun things.
Yeah.
He's well advanced.
Yeah. I was sitting with him for a little while, and he was talking to me when in my beginnings here. So, but
sure, good.
Yeah. So that's basically the bond draft and setting it to zero. And what about tracking it?
Explain your question.
If someone did make the mistake of not putting the bond in escrow and actually sent the party the original document and didn't have any like UCC ones or any public records of that being filed anywhere, so that way the public.
Yeah, well, it may be unretrievable. I don't know. So you might just have to go and do the process over again and do it appropriately.
Okay, because it's probably going to be stolen. Now, I had some other questions. You can go into court as a third party or an accommodating party, and if so, is there a name? You know, when they always want to play the name game with you.
Yeah.
Do you have to provide a name, or you could just say, "I'm here as accommodating party," and I want the court to move forward and don't obstruct the motion or something like that, or.
Well, in the court, you can appear in the court in a lot of different capacities. perhaps the most powerful capacity is trustee for the defendant. The court knows that you're not the defendant. They know that you're not the all capital letter name, but they're trying to get you to answer for it as the surety. And so, so when you appear in the court, perhaps you say, give me your name. You might say, well, I'm John Smith. First off, I always wear a name tag in court. I always have my name tag on with my name spelled in upper and lowercase letters. And so I point to the name tag and say, this is my name right here. And if you put it in your records, anything different than this, then I'm going to sue you for it. Because that's a conversion. Basically, it's a conversion of a security. But in any event, so you might appear as the trustee, which is a very powerful position. You might appear as a third-party interest intervener, third-party interest intervener under injury, something like that. So there's all kinds of ways you can appear to the court.
Yeah. So say you're appearing for the person you're using. Say you're there for John Doe, and the judge goes, "Okay, you're the trustee or you're the third party. So who are you? What's your name?"
Ask him what his name is.
Well, they'll say, "Well, I'm Susan Clark." Or
no,
something.
they won't. They won't tell you their name. They'll point to what?
They don't have name tags up here.
So I point to my name tag too.
No, I'm saying they don't have the name on the bench.
Oh, they don't?
No, they don't do that.
So if they won't give you their name, why would you give them yours?
Well, they'll give you the first name, I think. Some
Give
guys.
your first name.
Yeah, and what a lot of the guys are saying that the judges don't have a name tag on their bench because they don't have an oath of office.
It could be something like that. I'm not sure what it is, but if they won't give you their name, then I would say something like, well, for it on the public record, since the judge or the magistrate refuses to give their name, I'm going to give their name as John Doe number 1. So now you've captured their name as John Doe number 1.
Really?
Well, sure.
And you would just put that in a memorandum later on in document.
You could see if you go into the metaphysical side of things, in order to manifest a thing, you have to create a name for it. And so you create a name so that you can manifest something in the physical world. And so if the judge refuses to give a name, then go ahead and name him. Now that you've named him, now you've created a title for him, now you can start to manifest certain things in the physical plane.
Yeah, I've tried. I didn't try something like that, but I tried. Or I was in court one time for myself, and I was asking questions, and they didn't answer, and I said, okay, on for the record, I believe the agreement is this, and the judge jumped out right away. No, I didn't agree to that. I didn't agree to that.
You just did, partner.
Yeah, by them denying is admitting.
Of course. He fell right into the fiction. That's his problem.
Well, she was pretty intimidated because I was wearing my regalia and my feathers and everything, so I think she was distracted and very, very wanted me out of the courtroom as fast as she could.
Can you speak your native tongue?
Yeah.
Well, speak your native tongue when you go into court.
Oh, I do.
Great.
I do, and I say I'm only speaking English for communication purposes only, and doesn't waive any of my jurisdictions, and I'm not taking a benefit by using your language.
Yeah, absolutely. Yeah, I've recommended to people, especially the tribal members, when they go into court, at the very least, start out all conversations in the native tongue. See, in order to establish yourself as a nation, you have to have a language. You have to have land, and you have to have a history and tradition. Now, you went in dressed with your tradition. In other words, you had your regalia, your feathers and all those kind of things, which established that part. Your land is your body, and then if you speak the native tongue, that demonstrates that you are a nation.
Yeah, and I think that's what got her very. She didn't know what to do. She didn't know what to do. Like the counsel didn't say nothing. Nobody said nothing. I just asked them, "Did you get my private record?" And she's like, she's fumbling through her things quickly, and she didn't have it. And I said, well, I got it for you here. I got another copy. Hit her and the counsel. And I said, does the public have any jurisdiction over a matter settled in the private? And she said, no. And that was that.
Yeah. I was talking to a fellow up there, a native man up there, I think in central part of the country one time. He was involved in a legal case, and he had a whole stack of paper with English written on it. I said, throw all that crap away. I said, go state your claim on a piece of doe skin and turn it in. I said, write it in your native tongue. I said, go turn that into the court. He never did. He went to jail. But in any event, especially where you're dealing, with Native people or First Nation people or however you want to say that thing, when you appear in the white man court, for crying out loud, appear in your, in your national sovereignty.
Yeah, well, that was my idea, and I had about 15 guys that followed me to watch the show. Yeah, 3 hereditary chiefs came to watch the show, and a whole bunch of other gentlemen who come to me and ask me for help came to watch the show, and they ain't seen nobody go into court like that, and they never ever seen it. Because before I got up there, that woman judge was telling everyone what to do, and it was very, very you're going to do this, and you're going to do that.
She can't speak to a sovereign like that now, can she?
No, and she didn't. She was very taken back and very confused and didn't know how to address me, and was being very polite. And a week later, I got letters from the other party saying that they were releasing all their claims.
There you go.
So
you can't make a claim against the sovereign.
Yeah, I mean, they got it there, and they were videotaping it. So
good.
So that's some of the stuff I'm doing up here, and that's why we come to you just to get a little more clarity on, because sometimes I don't think people ask the right questions at some of the seminars. They're either too afraid or
Sure.
and some of the finer the brush details need to be asked in order to
there's actually quite an art to the ability to ask a question.
Yes.
I mean, it's an art in and of itself, and so the appropriate words may not formulate in their mind yet, and so sometimes you have to stimulate a little bit, and so to get the appropriate question asked.
Well, I always look at it as ask king, as and king.
Uh-huh.
So as being in a meaning in a capacity of, and then king being capacity of a king. So that's why I always like to be in a position of asking.
There you go.
But the last thing, or not the last thing, but the one thing I brought up last time was, what was that whole deal with, if I have another party in default, and I fill out a 1040 ES, and I do a documentary draft, and I send that to IRS, and they liquidate, and then like that I got that whole thing. I just didn't know, why the 1040 ES and why.
It's the 1040 ES is necessary to pay the taxes. The IRS needs to know what account to charge it against.
And so would you use the SIN number or whatever number that you're using in the public?
Uh-huh.
And then and that's your pass-through account.
Yes. That's your pass-through Treasury Direct.
Okay, so you're paying a tax on, say you had somebody for $100,000.
You're not paying a tax, you're adjusting the tax.
Oh.
Those are two different words, two different concepts. So you're not paying anything. You're adjusting the account. You're allowing them to use your pass-through for the taxes because you have the exemption.
Right, because you can't pay anything. There's no money to pay.
You can't pay anything.
Yeah.
Everything's an adjustment of the books.
And that's why you all say, please adjust your accounts to zero to reflect my zero balance on my statement of account.
There you go.
Because IRS can liquidate people up here in Canada, and how does that affect people's indemnification bonds and hazard bonds if you put in the contract that they forfeit it by their conduct?
Well, the example probably referring to was a friend of mine was in a court case, The judges were misbehaving from the bench. The clerk was removing documents from the files. He couldn't make any headway with them. So we went ahead and put in a distress on bond. We put it directly into a court pleading. It was in the form of a typical commercial lien. So we put that distress into the court. They did not act upon it. So based upon their dishonor of the distress, we went and created a bill of exchange, or what was called a documentary draft. We took it to the notary for presentment to state risk management, for their honor or dishonor. And so they did not come in to honor the draft, and so the notary gave him a certificate of dishonor. So he took that certificate of dishonor, he did an acceptance for value on the original documentary draft, sent the whole thing to the IRS, and then they went and collected on the documentary draft. The end result was that, the judge came off the bench and they put a new judge in there, and the new guy coming in knew what had happened. He didn't want to risk it himself. So that's how we got the court to act properly.
Yeah. Or you could, or other public entities that aren't acting.
Oh, sure. You can use it in any case. I don't really like the IRS, but we do use them for some things. Yeah.
And I find that process really, really interesting, because it's like sicking the dog on themselves or something. Like,
yeah.
It's like, they'll eat their own kind,
Absolutely.
And that's what I really like that. And what I'm trying to really get people to get in their mind is to stop thinking that these documents that they're doing is going to get them rich or get them money.
Oh no, these are all non-cash items. People got to get that straight in their brain. These are non-cash items.
Well, a lot of them are under the impression that they're going to get paid at the end of this UCC 1 filing and all that other stuff. And
well, they're not going to get paid in the way they're thinking.
Yeah, they feel that they're going to get a check at the end, and I'm like, man,
it's possible. It's possible, highly unlikely. Yeah,
just like you're talking about court case and civil cases that are won and never paid out because they didn't indemnify or subrogate the case, so they weren't the beneficiary of the civil.
They had no claim upon the money, and probably there was no money involved. That one story I give about the guy whose sister got sued for for a wrongful death suit. A case was against her for $3.4 million, and he took in as a third party a promissory note into the court administrative offices, and eventually, it was. At that point, then the money was available if the plaintiff would come in and make a claim for the money. So you have to understand that about 98% of all civil cases are never collected because there's no money to collect. You see?
Yeah.
So what we did in his scenario is we went ahead and made sure that there was money to cover that judgment, and there was. The court administrator said, yeah. He said, now we got the money in case anybody comes in and makes a claim for it. And so in other words, the attorney for the plaintiff couldn't go and seize their house or seize their cars or their bank accounts and all that kind of stuff because the money was right there in the court for them, $3.4 million. So, in those situations, you are talking about a cash event because the comptroller of the county comptroller of currency would, in fact, take that a note to the federal window and have the money on deposit with the court.
Yeah. But you're saying if you subrogate or you send in a bond for that case, you can become the beneficiary of it.
You can, if you understand about subrogation and so forth. These are kind of complex concepts, and I don't think you want to give some of that information to beginning students.
I guess you put little seeds in there and let them I've done that some of the future things that can come. You know what I mean? Because a lot of people don't know where to go. Like they're like, oh yeah, it's great we get a contract. It's great we do up these documents, and then what? Yeah. Then what? We just hold the paperwork and what? And I'm like, well, there's enforcement things you could do, but they're they're like, I want to get paid. I got a damage. I got beat up, or I got stuff stolen from me. I want compensation. There's been a tort, you know.
Well, if they go sue a civil case and they win the case, they can go put the promissory note in for the defendant. Now, can't they?
How does that work? What do you mean?
Well, say I sue you for $1,000 and I win the case, and you ain't got $1,000. So I would go put a third party promissory note in on your behalf, and then I could go make a claim for the $1,000. Now that might sound screwy, but that's the way it would work.
That's funny. And what? How do you make a claim? I mean, when you say make a claim,
go to the clerk of the court, and say I'm making a claim on the money in case there was such and such. I need a check for it. They got the money on account.
So you would make the promissory note out to the court or to the plaintiff, or like how to?
Out to the court on behalf of the defendant.
And so for the benefit of the defendant.
Yeah, just tell them. Well, they don't care what you say. So you go into the court administrator, or whatever, and say, look, case number 123 over here. Here's a promissory note, for that case. And so they take and monetize the thing, put money on account, and then once the money's on account, you go make the claim for it. I mean, we could talk about it.
That's such a I've never heard of that. I've never heard anyone. Yeah, well, I knew that. I was some of the ideas I had for the evidentiary jacket or the miscellaneous filings is I thought if we gave them an original promissory note, could say we did it for
$5 million. No, not the miscellaneous.
Well, I was saying if you put a $5 million note into the folder and you had a file number.
No.
And you went and did some money orders.
Now. See, you're getting your thinking backwards. A promissory note is a discharge item. There has to be a debt established before you can tender a promissory note. Okay. You couldn't put it in a miscellaneous file. There's no debt. The debt's created when the judgment is made.
Or if there's a default.
Well, a judgment could result from a default, yeah, but there's no way you can use a note in a court situation unless there's a judgment.
So yeah, that's that whole promissory note thing. That's I've never heard of such a thing. Like, have people had success doing something like that, or
$3.4 million? I just told you the story about the guy who did that for his sister.
Wow, that's awesome. And so would that promissory note need a registration of some kind, or like
he took in a promissory note. He went to the court administrator. The court administrator gave him an exact number, right down to the penny. And then he took that note, that original signature note, to the court recorder. They had an actual recording office right there in the court administrator's office. So he took the original to them, brought back a certified copy back from the recorder to the administrator, who put it into the file. He put the certified copy into the file. The recorder took the original to the county comptroller. The county comptroller took it to the federal window, got the money, put it in the court's account. And so then it was ready to go. As soon as the plaintiff or the attorney for the plaintiff made a claim on the money, it was there for him.
Wow.
See, all liabilities of U.S. citizens are the liability of the United States government. So they have to pay it. And that's the process that's used, to do it. And so the plaintiff ended up with $3.4 million. Minus attorney fees. I don't know what the attorney got out of it. He probably got a pretty good cut, but anyway, that's how it actually happened.
And I wish the U.S. courts were doing that like work that way up here in Canada, because I'm sure it does. I'm just not. I'm sure
it's the same process. You might just have to have a few different nuances and whatnot to get it done. But that's the way it's the way it works all over the planet.
Yeah, because I'm sure I've never heard of that before happening, and I'm sure it's all private and there's no court records that someone can go and point at and say, here, go to this court website and you'll see the transcript.
Now,
Or,
why would the court tell everybody in the public that?
Well, I always get people saying, well, show me the law, show me the court case that this worked.
Well,
and
we
I'm
just
like,
figured it out and went and did it. That's all it amounts to.
yeah. Yeah, it's like, well, they're not going to show that. They'd be crazy. They ain't
Well,
trying to
if
show-
you went down to that court there in Florida where it was done and drew up that case number, it would show it.
Oh,
Well,
really?
of course it would. The accounting is right there. The public file is the accounting. It's all there.
Wow. I mean, that's amazing stuff. Here's one of my books I am recommending people to read and to
Okay.
at least study from. It's a UCC one, but it's a contract book, and it has such great examples of what's a contract and case law and
Sure.
a lot of good material. Because I said you could listen to me all day, but until you pick up a book and start reading this stuff and start looking at some of the stuff that they're actually talking about, because a lot of people can't believe any of the stuff that's going on. Like they literally can't. They said this. How come lawyers aren't doing this? How come there's not more people? If this was true, how come everyone's not doing it? That's the kind
everybody
of
don't know
approach.
to do it. That's why we have seminars and education. A lot of this stuff, there's no book that you can read that's going to describe all this stuff. We simply had to go dream it up, go do it. Then once it worked, then we say, okay, now here's how that works. Because it's kind of like walking through a minefield. You don't know till you get out there what's going to work and what's not. There's no book you can read to figure this stuff out. You just have to go and play with it, which is what we've done.
Yeah, and that's what I guess that's one thing. I guess that we're doing up here. I guess I'm taking some of the examples that you guys do, and then trying some stuff out up here in the Canadian system. And the one thing I don't is if you send your bonds through registered mail, is that how you're registering the bonds, or does the UCC one filing register it?
If you're going to send it that way, then put the registration sticker directly onto the bond.
Yeah, that's what I've been doing.
Okay.
And so what does that do? That registers that?
Registers with the post office, yeah. The UPU.
And so if they do anything now, you could track it through the UPU or have the post office track it.
Of course.
Perfect. No, I mean that's good. And then I remember you saying that you would reserve like 1001 through 4001.
Oh, you could if you wanted to. If you just want to put notes on that on the bond on the UCC that way as a registration. Then when you issue a note, then you would do a UCC 3 transfer
assignment.
Yeah, assignment.
Now how would you like? Because I ain't never seen anyone do that. What would you say? You just put the note number and that's it?
It's just a way to track the note itself.
Yeah. So what? I guess you would just put the note number down.
Let's say you reserved 1,000 through 5,000, and so you issue a note 1,001. Then you would go ahead and do a UCC 3 assignment of note number 1001 and send that UCC 3 assignment along with the note when you send it. Tracking.
Yeah.
Or in a lot of cases here in the States, we have certified mail and they have little stickers. So we would actually take the sticker and put it right on the note itself as a tracking number.
And you wouldn't have to put the amount that the note was for, would you, in some way? Or like, how does...
It depends on the circumstance.
Yeah. Yeah. And so it's put in the collateral box then?
Yeah. Uh-huh.
Okay. And I'm just trying to kind of... Because when people do this, if they're going to fill it out, they're going to wonder, well, what do I put in there? Right? I put in the promissory note number.
Yeah, I just haven't put the promissory note number in there. There are other things you can do with the UCC3, but that's a little bit advanced technology, and I don't think I want to go into that.
Yeah. Okay, I mean, I think we've exhausted a lot of this beginning UCC stuff and bonds and courts and contract, and we really appreciate your time and thank you a lot. This is going to benefit a lot of the folks who are listening and folks who do get this file or access to it a whole lot. and we'd like to give you, in our language, we say a Nyawangoa, which is a way of saying a big thank you.
Okay.
'Cause,
Well, you're welcome. In my language, welcome. You're welcome.
Yeah. And from what I understand, when someone says thank you and someone says you're welcome, that usually means you're there's no obligation.
There you go.
You know, much obliged. You know that whole thing.
Yep. There you go. Much obliged. There you go.
Yeah. So we're gonna end that recording from here, Winston, and have yourself a great evening. And we're gonna cut the recording here.
Okay. Yeah, I got some other appointments that I got to get to here, so we'll cut her off, and I'll catch you later.